Welcome to the Jenny Beth Show.
The FBI director who's signed surveillance warrants on Americans leaked classified memos when he got fired and called himself a higher moral authority, James Comey, has been indicted again for what looks like a threat against the President of the United States. And today, the Supreme Court of the United States heard what may be the most consequential immigration case of this term. It is a big day, and we have two of the best legal minds in the country here to break it all down. Welcome to the Jenny Beth Show. I'm Jenny Beth Martin. The Supreme Court heard oral arguments this morning in Mullin versus Doe. That is the case over whether the Trump administration can end temporary protected status for hundreds of thousands of Haitians and Syrians. It is the final scheduled argument day of this Supreme Court term. Also yesterday, the court handed down a major ruling in Abbott versus Lulac, approving the Texas congressional redistricting map 6-3, just in time for the 2026 midterms. And actually, that was Monday, not yesterday, but that happened this week as well. And separately, the court agreed this week to take up a case next term about H-2A agricultural visa enforcement. And then there's James Comey, the same man who ran the FBI during Crossfire Hurricane, the same man who leaked his own classified memos to the press. Yesterday, a grand jury in North Carolina indicted him on 2 felony counts for posting a photograph of seashells arranged to spell out 8647. Comey's lawyers will claim First Amendment protection. Our guests are constitutional law experts who know this body of law cold. First, Carrie Severino, president of the Judicial Crisis Network, former clerk to Supreme Court Justice Clarence Thomas, and she's one of the sharpest legal analysts in Washington. She is with us in the first half of the show. Then, in our second half, Dr. John Eastman, Senior Fellow and Founding Director of the Center for Constitutional Jurisprudence at the Claremont Institute, and who also clerked for Supreme Court Justice Clarence Thomas, will be with us. And we'll close with something that actually gave me a smile. King Charles wrapped up the state dinner last night. He addressed a joint session of Congress yesterday, and he made 2 jokes that I think Americans will appreciate. More on that at the end. Let's get to it. Carrie Severino, welcome back to the Jenny Beth Show. It's great to have you with us today.
Great to be here.
Carrie, there is a lot of breaking news related to the Supreme Court today. First, the court issued a 6-3 ruling on the Louisiana versus Calais case, saying that racial gerrymandering is unconstitutional. Justice Samuel Alito wrote the opinion for the majority, and they said states have used racial gerrymandering to create majority black congressional districts for decades. Clarence Thomas, for whom you clerked, issued a separate concurring opinion saying he would have gone further than what the court ruled and said that no Voting Rights Act Section 2 challenge to districting should ever succeed. What do you think about this case, and what are going to be the ramifications of the case?
Yeah, so the context of this case is obviously we have the 15th Amendment saying that everyone can vote regardless of their race. We have the 14th Amendment with the Equal Protection Clause in it. But the problem is early in our country, there was a lot of actual discrimination based on race and people trying to block Black Americans from voting. And the court goes through that history. And the Voting Rights Act said that they couldn't be doing those kinds of things. The problem is in the intervening years, that has been overread, getting way far away from the text of what the VRA says to require states to create these majority minority districts. And states were in a real bind. It was kind of a damned if you do, damned if you don't situation, because if they had to, we were being told they had to create these majority minority districts, they had to look at race to do it. But then, the Constitution is telling them, no, you shouldn't be looking at race. And so how do you even resolve this problem? The court today really helped by bringing us back to what the actual text of the Voting Rights Act says. So if states are, in fact, intentionally discriminating on the basis of race, absolutely, they can still be held liable. But what the court is trying to get rid of is what they called this reverse engineering of political gerrymandering arguments. And political gerrymandering, look, no one likes it, but it's something the court can't step in to put a thumb on the scale one side or the other. It's just not unconstitutional. So they're trying to take what's really political lines being drawn and then creating and pretending this is actually a racial claim. Now, with the way the court is looking at it, if the state is really being racist, they'll still be able to bring claims. But this is going to shut down kind of the Mark Eliases of the world who have made a huge industry out of just suing every single state and trying to make them redraw maps that generally are attempting to make them redraw them in ways that are going to favor Democrats.
Carrie, elaborate on that. What exactly has Mark Elias done with this, and how has he turned it into a whole industry for himself?
Well, basically, anytime a state draws lines that in any way favor the Republicans, or that even just are neutral and don't favor Democrats, they can argue in court, and they will. They'll say, no, this is actually discriminating based on the basis of race, because we all know that there are very strong correlations with certain racial groups. Now, those are breaking down in recent years, which is great. But I think historically they could say, oh, you're not really just trying to do maps that are favorable to putting certain Republicans in certain districts. You're trying to put Blacks in one district or another. And especially with the increase of computer technology, you can almost always find some way to rejigger these things to argue that, okay, this is going to help or hurt different racial groups. And there's so many factors you're balancing that they're bringing these claims. And very often, again, you put this state in a bind where if they're being told by one court, as happened with Louisiana, one court said, you're not considering race enough. You need to add a majority minority district. Another one, they already had one, they have to have two. Another court says, no, when you went to add that, you're looking at race too much. So it just was a constant churn of attacking, particularly Republican states. And this is something that they have just a huge team of lawyers they're doing across the country. I think that's going to be a much harder case to bring now, unless there's actual discrimination. And thankfully, we're not living in a world anymore where that's a very common practice. Hopefully not at all.
So in the decision today, they did not tell Louisiana to redraw their lines, correct?
Well, Louisiana will have to redraw their lines,
Okay.
because the most recent set of maps had this extra majority minority district that Louisiana says, yeah, we were looking at race to draw it because this one court told us we had to. And so now they're going to have to go back to the drawing board and try to create maps that address all of their same concerns, keeping coherent groups together, trying to make sure that these groups are cohesive and not these long, thin gerrymanders, but at the same time, not looking at race. That's the key thing. Is we're moving. This court has been very good in so many areas, students for fair admissions within the education area and now in the voting area. Let's try to move toward our colorblind constitution.
That would be a very good thing. Justice Thomas said Section 2 should never apply to districting. And isn't that's, as you were just saying, it's a radical departure from what we've seen for the last several decades. Is that going to happen where they never look at it the way you were just describing, or is it, or not? And how is his concurring opinion different from the rest of what the majority was saying?
Well, look, he joined the majority in full, as did Justice Gorsuch, who joined his concurring opinions. This isn't a separate analysis. He just said, in the very first place, I'm not sure districting even falls under what the Voting Rights Act is looking at. They're looking at, if they're doing things that are specifically trying to prevent members of a certain race from voting, that's a different question. That's what the Voting Rights Act is talking about, not districting per se. But he absolutely was in agreement with everything the court said. And I think that, again, will bring the Voting Rights Act back into the language that was passed by Congress, what it was really intended to prohibit, which is actual discrimination, not some kind of statistical games that we can play to try to make just regular run-of-the-mill political line drawing, which happens in red states, blue states, everywhere, in trying to turn it into allegations of racism.
Okay. And then one last question about this particular topic. If racial gerrymandering is harder to defend now, what happens to the existing majority Black districts, for instance, but districts that have been decided because they are a majority minority district, not just in Louisiana, but around the rest of the country? What if they use race in determining those districts in other states? What will happen with that there? Or do you know yet?
Well, basically what the court is saying is states cannot use race in their determination of their districts. So to the extent that states were basing their districts based on race, I'm sorry, that violates the Constitution and probably the Voting Rights Act itself. However, we'll have to see. I'm sure there's going to be follow-on litigation, and it's possible that some of those districts, based on some of the other neutral principles, would survive, but a state's going to have to be able to defend its district pointing to race neutral principles and not based on race itself.
Okay, I'm just taking a note for that so that later when I have to talk about it, when I'm asked about it in the media, I have those notes. It's really good information. And that court case came out just a little while ago as we were preparing for the show, and I was scrambling to read the opinion and to understand it. And since I'm not an attorney, it worked out so well that you were going to be on the show anyway. And we had you on because today, the Supreme Court heard the last scheduled arguments of the term, and one of those cases was Mullin v. Doe. And this case will determine whether President Trump and the administration can end the temporary protected status for Haitians and Syrians. There are 1.3 million temporary protected status holders in America today. And putting this just in plain English, put it in plain English. What does temporary protected status do? What did the administration say it has the authority to do with ending it? And what does a conservative argument look like for actually ending this TPS status?
Yeah, so the TPS is here because we have people who the government has determined can be deported to their countries of origin, but there might be something going on there that means that for humanitarian reasons, we're not going to send them back. If you are being sent back to a country that's in the middle of a war right now, if there's a natural disaster currently happening, these are kind of emergency things. And as the name implies, temporary. It's not, well, this country is just kind of really dangerous all the time, and so we're not going to send you back there. It's supposed to be a confined status. The government is required to reassess it every 18 months. So they're not supposed to be just, rubber stamping this and leaving it in place for a long time. Unfortunately, practically speaking, that is what has happened. And the Trump administration has been going back and saying, let's actually look at these, because maybe not all of the temporary protected status holders, which then gives them status to stay here, to have a work visa, et cetera. Maybe we need to make sure that this is really doing its intended function. So for a series of different places, the ones that were issued in the cases today, Syria and Haiti, they said, we're not doing temporary protected status anymore. You can return to your country. And then this was challenged. The challenge is here that they said you didn't do enough consultation, because the statute does require that the Department of Homeland Security does consult with other agencies on this. And there were some emails that went back and forth, not a ton, but there were some. But most importantly, and this was the crux of the government's argument, it says explicitly that there is no judicial review of this decision. That means it's telling them to do certain things, it's telling them to do consultations, et cetera, but it is explicitly saying courts cannot review this decision. This is something that has to be made by the executive. There's all sorts of factors that might have to do with foreign policy and all sorts of national interest things that can't be reviewed by a court. And the big problem here is they're asking a court to review this decision. And I think that was the hardest thing for the particularly the originalist justices to get over, is like, guys, it says no judicial review. How are you opening the door then to judicial review? And that was those are some of the hard questions from these challengers, trying to say, well, okay, how are you going to cabin that in and not just open the door to exactly what the statute said you can't do?
Yeah, a district court did override what the administration did, so they opened that door. How were they able to do that, and what does it say about the district court?
Well, that's exactly why the Supreme Court took this case and took it on a very expedited basis, because they want to, especially when you have something like this that should be barring review ex ante, like at the very beginning, they shouldn't even be in court. Then making the government jump through these hoops, and particularly on issues that are urgent and of serious national importance, you can see why the court doesn't want to get that wrong, because otherwise you're dragging the federal government through having to make a lot of proofs and maybe having to reveal in court things that could have been really part of their internal deliberations. They shouldn't be allowed to do that. I think that's part of the reason the court took the case, because they want to make sure that district courts aren't just light handedly just going through this very clear statutory bar on judicial review.
Okay, that makes a lot of sense, and it explains why they did it in such an expedited manner. Now, some people on the left will say there are 350,000 Haitians, 6,100 Syrians who are here, and they've been here under the temporary protective status. They've built their lives, and some of the designations go back to 2010. So shouldn't they just be allowed to stay? But what is a constitutional argument about this? When I just read the phrase temporary protected status, it seems pretty plain to me. It means temporary. It doesn't say permanent protected status.
Exactly. And the fact of the matter is people who have temporary protected status are deportable. It's been already determined that this is someone who is not legally here. So if it weren't for the conditions in whatever country they came from, they would already have been sent back in 2010 or whenever they received the status. And the very fact that there's people who've had 15 years of temporary protected status illustrates it's not been used the way it was intended, right? This is, again, supposed to be for a finite, urgent issue that's going on, and not just once you're in, and now you stay on. Of course, there's always, concerns back and forth, and you feel for people who have been here for a long time. But the reason they have that 15 years here is really because the status hasn't been reviewed as it really should have been over this whole time. So that's on the federal government for not treating it properly up until this point. That doesn't mean we should continue to abuse temporary protected status.
I completely agree with you on that. And I agree with the administration. And I appreciate the fact they're trying to clean this up and get it right. Did you listen to the arguments today?
Yeah.
So when you were listening to the arguments, what did you hear? Were there any signals that you heard based on the questions the justices were asking?
Yeah, I think I from what I heard, it seemed that the constitutionalist judges, the originalist judges, all seem to recognize, because they're all textualists. They all look at the meaning of the words. I think you're going to get at least 6 justices probably voting to maintain this judicial review bar. That's not a vote that they agree that this country or that country should or should not have temporary protected status. That's a vote saying we're not the ones who get to decide, because that's what the statute is giving to the president. I think there's some arguments, Justice Kagan's questions leave possibility open that she could even join those justices. So that was really interesting. There were some great exchanges that Justice Kagan, or Justice Barrett rather, had a good exchange with the attorneys attempting to get this temporary protected status extended. And she said, well, how, she was trying to get them to limit what they were saying. Like, if we can review this, how come you're not saying we can just second guess anything the president or the Homeland Security decides on this front? And they said, no, we can just review procedures. So as long as you have enough emails back and forth, regardless of what they say, that you've checked the box on that. And Barrett called them out and said, that sounds like you're just asking for a box checking exercise. How is it that you're trying to turn this statute into just a mere box check, now suddenly gets you off of it? So I think that was a good indication of where she probably stands on this issue, and I think a good indicator of where the court's going to ultimately stand.
Okay, that is good information to know, and I am prayerfully optimistic that the court will make the right decision on this case. It seems like it's pretty cut and dry on this particular one, with the actual title, temporary, and the fact that it says that courts are not allowed to intervene. But I guess we'll see what the court does when they come out with their ruling. Carrie, today the Supreme Court had another decision, correct? It was a unanimous decision that involved First Choices in New Jersey. What is that case about, and what did the court decide?
Yeah, so this is about First Choice Women's Resource Centers. It's a crisis pregnancy center in New Jersey that has become the target of lawfare, as we so often see nowadays, in this case by the New Jersey itself. And what New Jersey was attempting to do is get their donor information revealed. And they're claiming that they're doing an investigation, that they want to make sure that they're not holding themselves out as an actual group of promoting abortion, because they're a pro-life pregnancy resource center. And that their argument is donors don't know what they're getting into, and they're being misled. I think that's a pretty big stretch, but that's their argument. The biggest problem there is what they're trying to do is get information that they constitutionally cannot access, which is forcing them to reveal anonymous donor information. The Supreme Court has been very clear on this issue. Just a few years ago, they had a case where they said there is a First Amendment right to anonymous speech. It's both a free speech issue and really a freedom of association issue, because so many times, as we have seen increasingly in recent years, but as the founders recognized as well, if you can reveal the names of these anonymous speakers, now you can attack them. That's why so many of the early Federalists didn't have sign their name to it. You had people like Publius writing, and they were writing things that they knew they were going to get in trouble for, and they wanted to have a right to say them without putting their personal lives and selves at risk. That's the same thing that's happening here. There were donors to this crisis pregnancy center saying, we might not have donated if we knew that we were going to be outed. We've had people getting fired or getting attacked because of their positions on this issue. In this case, the actual decision came down a little bit to some wrangling about which court, federal or state, was going to decide this issue, and whether the New Jersey government could require them to release this information before they litigated their claims about their First Amendment rights. The bottom line at the end of the day is that the Supreme Court unanimously said, if they were forced to do that, that is a huge constitutional violation. They don't need to show that they lost, an X number of dollars over it. If violating their constitutional rights to keep that associational information of their donors private, that is enough to bring this case. And I think this clearly points to the fact that First Choice is going to be able to protect itself against this kind of lawfare going forward. And that's really good news across the country, because we know they're not the only people who are being subjected to this.
Well, Carrie, it sounds very much like the Supreme. And I wasn't. I was trying to learn about this one this morning before we went on the air as well. But what you're describing right now, it sounds very much like the Supreme Court case back in the 50s, I believe, that had to do with the NAACP, right? And that's where it said that they are allowed to protect the people who donate to nonprofit organizations. And it sounds like the court is reaffirming what it has already said. And as someone whose group was targeted by the IRS, and the IRS was asking for a list of donors and list of donors of local Tea Party groups as well, and they wanted back-end access to our website, I'm glad the court is taking this stance and protecting donor privacy. And I would want that even if it was a leftist group. It applies no matter what. We have the right to be able to speak and to do so anonymously if we choose, as long as we're not inciting violence.
Absolutely. And there's the NAACP case, and then there's a recent case involving Americans for Prosperity. It's the same principle. We have this right to freedom of association and freedom of speech, and that should apply whatever your position is. I think that's why you saw a unanimous court today come down with that decision. It really, as Justice Gorsuch put, the question before us all but answers itself. and the court below had said they haven't been injured if they're forced to disclose this information. The court said, absolutely not. If someone's violating your constitutional rights in this way, that is per se an injury. And I think that was the right answer.
Okay, I'm really good. I'm really glad that you were on to be able to explain this, because I wasn't quite sure of the details with it, and I am very glad about this decision, and I'm glad it was unanimous. And if it'd been Planned Parenthood, or it had been some leftist organization who I don't agree with what they say politically, I still would I would want their rights protected. So I'm glad that this particular case has shaken out this way. Okay, we're at the end of the time for you. I have a really quick question, and I don't want to put you on the spot or anything. I hope that it does not. Yesterday, the King of England spoke before Congress, and there was a state dinner, and I just was wondering, what were your thoughts about that visit?
Well, it's really exciting to have them here. We had a lot of members of the Supreme Court there in my bailiwick, but I think he gave a nice speech, including some jokes about how they didn't want to burn the White House down this time they came to Washington, D.C. So it's nice to see, the good relationships continuing between our countries.
Absolutely. Well, Carrie, thank you so much for being on with me today. And then remind our audience where they can go to follow you on social media and to get more information.
Yeah, I'm on X at JCN Severino, and our website's judicialnetwork.com. I also blog regularly at Bench Memos blog at National Review Online.
Perfect. Thank you so much for joining me, and I really appreciate it. And I'm glad these cases and the rulings came out today on the day we already had you scheduled. It worked out perfectly.
Great. Good to talk with you, Jenny Beth.
Thank you, Carrie. Okay, so before our next guest, let me give you the call to action, which is the same call to action we've been doing all week, but it is very important. We need to make sure we are working to pass the Save America Act and to fully fund the Department of Homeland Security. The call to action specifically is for you to go to our website at passthesaveamericaact.com. Again, passthesaveamericaact.com. And you can sign up there to send emails to your senators. The other thing that you can do is you can dial 202-224-3121. Again, that's 202-224-3121 and tell both of your senators to pass the Save America Act and to fully fund the Department of Homeland Security. All right, we will be right back. And when we come back, we'll have Dr. John Eastman with us. Dr. John Eastman, Senior Fellow and Founding Director of the Center for Constitutional Jurisprudence at the Claremont Institute, John is with us next. John Eastman, thank you for joining me. I'm so glad you're with me today.
Jenny Beth, thanks so much for having me. And it's good to see Carrie and all the great work she's doing as well.
So, John, you have argued before the Supreme Court. You clerked for Clarence Thomas, and I am wondering, what did you think of the ruling that came out this morning regarding the Louisiana versus Calais related to redistricting?
I think it's a very important decision, and it's been long in coming. The court has clearly telegraphed that it was heading this direction for decades now, going back to a very important line in Justice Scalia, an old Justice Scalia opinion, says the way to stop racial discrimination is to stop discriminating on the basis of race. And unfortunately, for decades, the Democrats, because of a very large proportion of African American voters that vote Democrat. Now, President Trump has got that changing in the right direction, but 90% for many years, that they could use race as a proxy for partisan advantage, and everybody would keep their hands off of it. The Supreme Court's no longer buying that, and I think the decision this morning makes manifestly clear that we're not going to tolerate people being, thrown, snake-like districts drawn to pick up every black voter, anywhere in the state and trying to throw them all into a single district.
And then we had a case on Monday that was related to redistricting as well. The court approved Texas's redrawn congressional map 6-3. We have the ruling up on our screen there. The dissenters were Justices Kagan, Sotomayor, and Jackson. They were all, of course, Biden and Obama appointees. What is the constitutional principle at stake in the case from Monday? And what do both of these rulings, how will they affect 2026 and beyond when it comes to congressional districts?
Well, and I think first important thing to note is the difference between the Texas redistricting plan and what California has tried to do and what Virginia has tried to do. Texas's plan was designed in 2020 under Biden administration officials after they got elected to actually further race-based gerrymandering. And so what the Texas legislature did is unravel that and try and produce a more fair map. On the contrary, in the case, the redistricting plan struck down today in Louisiana was doubling down on the use of race in drawing those districts. Virginia and in California, they were doing something very similar, skewing things for partisan advantage, but hooking onto race as well. So I think that Texas was cleaning up an unconstitutional violation. I think California and Virginia going forward are trying to increase new constitutional violations. Although I will point out the legal challenges that thus far have been successful to Virginia are all based on state constitution, not the federal constitution. And I think the challengers to the Virginia map are going to prevail on that. Certainly based on the direction the state Supreme Court seems to be going after its hearing on Monday.
And I am very prayerful about that one, and I'm afraid to be optimistic, so I'm just going to continue to be in prayer about that one, because that, I think, is all I can do at the moment to help with that particular case. John, there was a case that the Supreme Court heard this morning, Mullin versus Joe, and that has to do with whether the Trump administration can terminate the temporary protected status for Haitians and Syrians. The statute says that TPS, temporary protective status decisions, are not subject to judicial review, but lower courts have been blocking the administration anyway. What is the separation of powers argument here?
Well, there's a couple of separation of powers arguments. In general, Solicitor General Sauer was asked directly by one of them, by Justice Thomas, said, does Congress even have the authority to intrude on your executive discretion in the foreign policy arena? And General Sauer said, look, we're not challenging that in this case, but we do think that Congress's decision to what they call a judicial review bar, to prevent judicial review of these discretionary decisions, is a separation of powers between the executive and the judiciary that Congress put in place. Now, the challengers are making a very interesting argument. Well, that just applies to our ability to block the final determination, but it doesn't affect our ability to say all the steps leading to that final determination were not proper, and so therefore we're going to enjoin the final result because of the interim steps that were taken. And the couple of things they're resting on was, the secretary did not fully engage in dialogue with the deep state folks at the State Department before she rendered her decision. But this is part of the problem. And one of the reasons President Trump was elected is because the deep state has become so entrenched that it was not following the directions of the elected guy in the White House that we, the American people, put in. The second piece of this that I think is very interesting is the claim that somehow the deep state has to be able to make their own judgment contrary to the directives of the president. And this is one of the longest running fights now in this administration about the authority of the president to direct the executive branch to comply with his political agenda. That's the system we have. It doesn't say the executive power is vested in the president and however many unelected bureaucrats Congress wants to create. It just says the executive power is vested in the president, period, full stop. And so if the president issues a directive and said, I think we need to review these TPS statuses to find out if the statutory criteria are still met, and if they're not still met, to revoke those criteria. That's a directive from the president. He's the head of the executive branch. And he's actually, executive order says, let's comply with the criteria that Congress set out in the statute, even though presidents have said you can't impose on us that, but we can apply with that. And I don't think Syria and Haiti qualifies anymore. The circumstances that 20 or 30 years ago led to TPS status for Haiti. And I remember it was after a huge hurricane devastated the island. Those circumstances no longer exist, and they haven't existed for decades. And yet we keep repeating and renewing the TPS status because, it's a poor country. Well, this was not designed to provide people economic relief if the country is poor. It was called temporary protective status for unforeseen emergencies that exist in the country, whether civil war or devastating natural causes like a hurricane. It was not meant to be a temporary free pass to America because your country is not as economically successful as the United States is.
Yeah, and John, that's some of the stories I've read online, I guess, about it. Oh, the people have been here for a very long time, and because they've been here a long time, I read one this morning from the Associated Press that had interviewed a couple of people, and they're like, well, I guess America just doesn't want us anymore, and I don't feel appreciated. I've worked so hard here. And it says temporary. It says temporary protected status, and I want to help people. I want their countries to do better, but we can't bring every single person into the world. They will not all fit into America. It just simply is not possible. And giving the people of a country relief after a devastating hurricane in order for the country to rebuild is a good thing to do. I don't have an issue with that. That is a humanitarian type thing that the people in our country would want to do. And then once the country has rebuilt or has stabilized enough that they can begin rebuilding, people have to go back and work in their country.
You're absolutely right. And the definition in the statute, temporary, how do you rely on permanent, how do you have a permanent reliance on something that on its face says temporary? And then how do you get around the statutory bar of judicial review of the decision? Well, okay, I didn't consult enough with the unelected bureaucrats in the State Department who think everybody and all 8 billion people in the world should come to the United States tomorrow. And I didn't consult with them because quite frankly, they are taking positions that are contrary to American interests. And it says the decision whether to terminate temporary protective status is non-reviewable in the courts. I think we're not going to get Justice Kagan and Sotomayor and Brown Jackson. We're not going to get their votes. But it sounded like from the oral argument, and I wasn't able to listen to all of it, some of it cut off. It sounded like the other 6 justices are going to follow the statute and say, you don't get to have judicial review of this highly discretionary, highly foreign policy driven decision of the president and his secretary of state or homeland security.
Okay, let's shift gears to some other breaking news that has happened this week, and then I want to talk about things that happened to you a couple of weeks ago. Yesterday, we saw that James Comey has been indicted for the second time. This time, he was indicted for posting that seashell photo that was arranged to spell 8647. His lawyers, I'm sure, will argue he had First Amendment protection. Before I ask you a couple of questions about this, let's listen to what both Kash Patel and Attorney General Blanche had to say yesterday.
As you heard from the Attorney General, the U.S. Attorney, former FBI Director James Comey, has now been indicted for 2 felony counts. While many of you may read this indictment and view this matter as a simple investigation, it is the farthest thing from that. Every single investigation this FBI and our partners at the Department of Justice undertake, especially those that involve the threats to harm or hurt or even kill individuals, whether they hold public office or civilians in our country, are met with the same measure of investigative prowess and tools and personnel in partnership with the Department of Justice as anyone else. As the U.S. Attorney indicated, James Comey will be afforded every matter of due process under the United States Constitution. And as the Attorney General indicated, this has been a case that's been investigated over the past 9, 10, 11 months. These cases take time. Our investigators work methodically. They are career agents, career prosecutors who work these matters. They call the balls and strikes in the field as they see fit pursuant to the facts of the case and the law. They took that information and made a presentment to a grand jury, a jury of peers in the district in which the alleged crime took place, and that grand jury spoke, and that grand jury returned a 2-count indictment against James Comey. James Comey allegedly threatened the life of the President of the United States, and as you all now know, shortly after posting that threat, he deleted that threat and then issued an apology. All of that information was presented to the grand jury, and Mr. Comey will have his day in court and his ability to speak to a jury of his peers. Thank you.
May 15th, 2025, that the defendant, James Comey, knowingly and willfully transmitting in interstate commerce a communication that contained a threat to kill the President of the United States. Both of these counts carry a maximum term of imprisonment of 10 years. So I think it's fair to say that threatening the life of anybody is dangerous and potentially a crime. Threatening the life of the President of the United States will never be tolerated by the Department of Justice. Over the past year, this department has charged dozens of cases involving threats against all sorts of individuals. We take these seriously, every single one of them.
John, I'm sure, as I said a moment ago, that Comey's attorneys are going to say he had the First Amendment right to post the photo that he later apologized for and removed from Instagram. You know the law and you know Comey's history with the FBI. Do you think this is a legitimate prosecution, and does it survive a First Amendment challenge and other challenges so that it might actually move forward in the courts?
Well, there are First Amendment issues, and they will certainly be front and center in Mr. Comey's defense, and also when this case gets up to appellate court review and even potentially Supreme Court review. The standard by the court is you have the right to even encourage lawless action, and it's protected first speech unless the threatened harm is imminent. Now, when you've got somebody of Mr. Comey's stature who is saying 86-47, that means take out the president, and he's posting it on social media in a way that there may well be people that imminently seek to act on it. And then all of a sudden you're connecting the dots and meeting the Brandenburg standard. At least that's the argument I think the case is going to turn on. And particularly in light of the assassination attempt, not just on the president, but on a number of cabinet officials that were at the Washington Hilton for the correspondence dinner. All this guy seems to have driven by messages by people on the left, just like Mr. Comey's message was here. And so we're no longer playing in a sandbox where you can make these kind of vile threats without consequence and without triggering people to actually act on them relatively quickly. And I think that's where the fight is going to be on the First Amendment challenge, whether this meets that imminent risk of threat under the Brandenburg standard.
And as I was researching this case, a case from 2023 came up that apparently tightened the standard for what is a true threat. It was called the Counterman versus Colorado case. Are you familiar with that? And what is the legal standard for a true threat? And does that matter in this particular indictment?
Well, so we're going to have two things. Does it qualify as a true threat? So, some people can speak tongue in cheek. I don't think folks, for example, that held a mock-up of President Trump's head dripping with blood, one actress did that, can be taken as anything other than a true threat. The issue is whether it was immediate incitement to actually engage on that. Comey can argue, look, this is just, I put a bunch of stones together. It was kind of a joke. It wasn't a true threat, and nobody should consider it to be a true threat. But given his hostility toward President Trump and his frequent statements against President Trump, I think it's certainly plausible that, in fact, that would qualify as a true threat under the Counterman decision. These are the things that we're going to have to assess. He'll be filing motions to dismiss the indictment based on both of those, lack of imminence and lack of true threat. I think the court is going to say those are issues for the jury to decide, and we're going to end up in the Court of Appeals or U.S. Supreme Court ultimately deciding those questions. I do think they're close calls, but the fact that that part of the case was presented to the grand jury and they nevertheless issued an indictment seems to suggest to me that the grand jury already weighed in on that factual dispute and says there's enough here to go forward with an indictment.
Okay, and we'll see how that plays out and what the significance of it is. I would argue you don't go around making jokes of any kind that imply that you're going to bring harm to the president of the United States. There's some things you just don't joke about.
Well, and take another example. Some 14-year-old kid makes a joke about having a gun when he's going through TSA security. Yeah, the kid may have intended it as a joke, but TSA doesn't. And anybody that's been in that circumstance or seen that circumstance knows that there are just some things you can't do, that you don't have free speech to make such a claim. And that, I think, is where we're going to come down on here. By the way, the last thing I want to make about this, in my view, this is the tip of the iceberg of Mr. Comey's legal difficulties, criminal legal difficulties. He was up to his eyeballs in what I consider to be a nationwide conspiracy against the president's top advisors and supporters that led to unconstitutional surveillance of Americans, including members of Congress, that had led to phony dossiers against the president. There was a conspiracy to prevent the president from getting on the ballot and getting reelected. And I think we're going to see a lot more involving Mr. Comey come out in the process. But this is what I think this is a first step on one discrete issue for him and his legal troubles.
Okay. And the way that you describe what you're not allowed to say, for instance, at TSA, joking about having a gun. There are just some times when you might have the right to speak, but you need to be wise and responsible with your rights. Yeah. And you can't do things that someone else might interpret as a threat or gin up a crowd in a way that could lead to some sort of violence.
Yeah, so, and look, we have examples of members of the U.S. Senate threatening Supreme Court justices. And what happened after the Dobbs leak? People actually acted fairly quickly on those threats, those statements by sitting U.S. senators, and assassination attempts against Brett Kavanaugh, for example. These things are real, and so these kind of threats cannot be just written off as, oh, I was just playing with rocks in the sand. He first said, oh, I came across this as I was walking on the beach. Well, I'm sorry, that's a lie. He put the rocks together to send that message. He posted it on his Instagram. And the notion that people in this hyper partisan, violent consequence world in which we live, somebody wouldn't take that seriously and attempt to act on it is a dangerous presumption that's not supported by the evidence, it seems to me.
And I would agree there, and I guess we're going to see where the evidence takes us and how the justice system works out. And many days I don't have a lot of faith in the justice system, and part of the reason I don't is what we're going to be discussing next, and that is that about 2 weeks ago you were found to first you've just been the victim of weaponization from the legal system nonstop for five and a half, almost 6 years now. I guess it is 6 years now. And on April 15th, you were disbarred in California. The California Supreme Court upheld 10 of 11 charges, and you said you're taking this case to the Supreme Court. Explain what happened and why you're taking it to the Supreme Court.
Well, we were talking about the First Amendment issues with Mr. Comey. The bar court in California, the trial court, and California is unique. It has its own bar court system. Disciplinary matters are not resolved by temporary panels of lawyers, but there's actually a court system in place. And the hearing department said, because I had a client, I didn't get the same First Amendment protections that every other citizen gets. The U.S. Supreme Court has repeatedly said that's not true, including just a couple of weeks ago in the case involving psychological counseling for transgender or gender dysphoria issues. But also in a case a decade or two ago that I was involved in and counsel of record for, NIFLA, the California law that ordered pro-life pregnancy centers to advertise and have posted on their wall advertisements for abortion and how to obtain an abortion. So the court has rejected that argument. It gets up to the appellate division in the California Bar Court, and they say, yeah, the court's clearly wrong on that. We're going to apply strict scrutiny as we're required to do. But then it proceeded to apply a version of strict scrutiny that is unlike any strict scrutiny case I've ever seen. And all of this on top of unbelievable distortions in evidentiary rulings, calling of witnesses, and what have you. And I'll just give you one example. One of the key issues was whether any reasonable attorney would have filed a motion to intervene in the Texas versus Pennsylvania original action in the Supreme Court. I filed a motion to intervene on behalf of President Trump. 17 other state attorney generals filed amicus briefs in support of that action. 6 of them filed a separate brief seeking to intervene themselves by adopting my motion to intervene. So you would think that if the question is whether any other reasonable attorney would have done what I did, and 17 state attorney generals did exactly what I did, that would have been the end of the case. The judge ruled that those briefs were not relevant at all and prohibited them from coming in. But the briefs by the secretaries of state of Michigan or Pennsylvania that were challenging our positions were all admitted into evidence when the bar lawyers sought to admit them into evidence. That's just one example of the unbelievable double standard that was applied in that case and violates, in my view, due process rights. So we'll have first, the other thing is I wrote a memo and encouraged Vice President to accede to hundreds of legislators around in the swing states who had requested that he give them some time to assess the impact of illegality that they had identified in the conduct of the election. The bar court said I was engaged in a conspiracy with President Trump to obstruct the peaceful transfer of power. No, what I was engaged in was petitioning our government for redress of grievances. That's another part of the First Amendment. So we will now go to the U.S. Supreme Court asking them to reverse the California Supreme Court's decision adopting the disbarment recommendation because of these egregious violations of my First Amendment and due process rights. And because those are federal constitutional issues, the federal Supreme Court has authority to weigh in.
Good. I hope that they uphold your First Amendment rights. You were working on behalf of a client and you were not committing crimes. You should be able to defend your client to the very best of your ability. And one of the things that we heard, and I, as you know, I helped President Trump's legal team in Georgia. I'm not an attorney, but I'm good at organizing. And so I was doing some things organizing the complaints that came into the hotline and matching them up with volunteer attorneys to get depositions created that were used in his court case in Georgia. But one of the things that we heard back then was, oh, that is an argument. That is a constitutional argument that's never been argued before. So you can't make that argument because it's never been argued before. Well, just because it's never been argued before, because no one has thought of it before, doesn't mean it's not a valid argument. And it doesn't mean it's not a valid argument to at least try in a court of law to see if it will hold up or not. And I think that was some of what you were working on in your cases. And you weren't conspiring to do anything illegal. You were representing your client. And a candidate has a right to question the outcome of an election. A candidate has a right to ask for recalls. A candidate has a right to make sure their election was handled legally and properly. And that's what you were doing. You were representing your client to make sure those things could happen. So it's maddening to me that this has happened to you. And are you also under indictment?
Still under indictment in Arizona. We're waiting on the Arizona Supreme Court to decide on whether to take the Attorney General's appeal. That the Attorney General's prosecution has been now by trial court rulings invalidated or preliminarily invalidated on two different grounds. The first was my First Amendment rights. Arizona has a unique anti-SLAPP statute, which allows us to challenge the legitimacy of the prosecution if it was if we had substantial proof that it was motivated by a desire to chill or retaliate against the exercise of First Amendment rights. And the court has already ruled that we demonstrated our burden of proof on demonstrating that. And she now has to come back to try and prove that, in fact, that had nothing to do with her decision to prosecute us, which I think is going to be very hard for her to do. The second ruling that the court did was said that her presentation of the grand jury was so flawed and biased that the grand jury indictment, has to be remanded to grand jury for a more proper consideration after the more neutral assessment and presentation of facts are given to the grand jury. And so that's what she's appealing to the Arizona Supreme Court right now, because she doesn't want to have to go get a new grand jury who might well look at all the facts and say there's just nothing here because everything they did was legal. I want to go back to your point, though, about representing a client. When there are plausible grounds, both in fact and law, to take the client's position and advocate on his behalf, it's just not something you're allowed to do as a lawyer. It's something you are ethically bound to do as a lawyer. And because there has never been a decision, for example, about the role of the vice president versus Congress in the joint session of Congress, I think the argument is pretty powerful that the founders that drew up the language of the Constitution deliberately excluded Congress from having any say in the selection of the president. That's why the vice president has authorities that he has. That's an open constitutional question. And by definition, you can't be prosecuted or disbarred for advocating one side or another of an open constitutional question. In fact, if the constitutional question has already been decided and you have a good faith argument on why it was wrong and should be reversed, you're allowed to make those arguments. Think Thurgood Marshall challenging Plessy versus Ferguson's separate but equal segregation doctrine that existed for 50 years, and he kept pressing it. Under this standard, for him to have challenged the illegitimacy of Plessy versus Ferguson would have gotten him disbarred because the court had already ruled. That's not the standard we've ever applied before. And thank God Thurgood Marshall persisted in what he did to get rid of that heinous stain on our republic.
That is exactly right. And the Congress came back in after the 2020 election and passed a law that said what the vice president could and couldn't do. That law did not exist before that in 2020. So I think that lends to the argument that it was a wide open decision and question anyway.
Yeah, and if I'm right that Congress has no role here, that law is even more unconstitutional than the first one. But as President Trump said when we premiered my documentary at Mar-a-Lago, and he came and watched it with us, as he said, the fact that they repealed the law that Eastman was relying on demonstrates that they thought he was right. So I thought that was a very kind acknowledgement and a hat tip from the president on stage there.
Yeah, and I'm so glad he was at that premiere with you. So, John, how can people see that documentary? Do you know off the top of your head?
It's still available for free streaming, in part because the streaming platforms that had indicated they wanted to run with it have gotten gun shy about putting it up, because it tells the story about what actually happened in 2020 in greater detail than I think anybody else has done. It's still available at madisonmedia.org or .com. I can't remember. madisonmediafund.org. And it should still be on their front page, or you maybe scroll down a little bit on the front page. It's called The Eastman Dilemma. You could probably also Google Eastman Dilemma and get the link to it directly. The second thing, people can do is, look, I mean, we're still fighting this, and taking a case to the Supreme Court is just to ask them to take it is going to probably cost $250,000 or more. If they do take it, and then we have to go through the merits briefing and oral argument and all the prep, it probably would be another $1 million. So I've already incurred more than $2 million in expenses defending against 18 different actions against me. And people can go to my legal defense fund site, givesendgo.com/Eastman. They say we're getting close to the $1 million raise mark, but that's less than half of what I've already spent. I can't offer anything because then it'd be treated as a lottery or something. But whoever is the person that puts us over the $1 million mark, I will reach out to and try and figure out what we can do to highlight that they were the one that kicked us over that top. But we've got a long way to go on legal fees that we're going to incur. But I think it's important. It's not just me. I mean, there are hundreds of people that have been targeted for this barfare component of lawfare to try and scare lawyers away from taking on conservative client or causes that the elites in our country don't want anybody to challenge. And it's working. And so we need the Supreme Court to weigh in and put a stop to this, or we're going to destroy our adversarial system of justice.
John, I just looked at your website and you're at $994,972. So you need $5,026, $27 to get you over the top. And that website again is givesendgo.com/Eastman. givesendgo.com/Eastman. Donate to John Eastman's legal defense fund. He needs to be able to get this case to the Supreme Court and argue it, because the lawfare against attorneys is the lawfare against attorneys who support President Trump. If we don't win with Eastman in the Supreme Court, it will be worse in 2.5 years from now when President Trump's term is over and the people who've been working for him in this administration go through all of the same kind of, honestly, it's just pure hell that you've had to go through, John Eastman. It's wrong what they have done to you.
Well, thank you very much. And you're absolutely right. Look, they're already, the DC bar disciplinary process has already been launched against Ed Martin for him trying to implement the president's anti-DEI executive order. They're threatening any other Department of Justice official. The judge out in Seattle threatened the lawyers that defended President Trump's birthright citizenship order with a not too subtle threat to refer them for bar disciplinary proceedings. People on the left have been very explicit, not just disbarment proceedings, but criminal proceedings against any lawyers that are defending the president's initiatives. They talk about protecting democracy, but they will not abide by the results of the last election, where the American people very clearly elected President Trump to engage in the very kind of agenda-driven actions that he is pursuing and that his lawyers at the Department of Justice are pursuing. So they are trying to unravel the results of that last election and then prosecute people that actually try and fulfill the will of the American people.
And John, you mentioned Ed Martin. It's not just you and Ed Martin. There's been Rudy Giuliani, Jeff Clark, Sidney Powell as well. Cleta Mitchell lost her position at her law firm right after it happened. There are other attorneys who maybe don't have as much fame around them who've gone through a lot. Ray Smith in Georgia he was one of the people who was indicted in Georgia. He represented President Trump in the case in Georgia. The list is, it's absolutely, it's shocking how many people. And the left thinks that President Trump is weaponizing things. President Trump isn't. If he were doing that, there would be so many more people who have been under indictment with President Trump. They're actually looking for real cases, not what's happened to you.
I'd add to that list one of the most egregious things, very distinguished former judge in Wisconsin named Jim Troupas, who's under criminal indictment and with, unbelievably biased judges who, this case should have been thrown out the first time it got into a courtroom, and it wasn't. And they're doubling down on going after Jim Troupas. Look, all the people that are claiming it's Trump weaponizing the Department of Justice, I feel like, the playground monitor who doesn't see the bully punching people in the nose day after day after day, and then finally turns around and sees the kid that's being bullied punch back for the first time, and it's that person that he goes after. You got to look at this in the broader context. The decade-long lawfare effort against President Trump, him responding to it is not to play tit for tat and do lawfare in kind. It's to hold the people accountable that engage in that unlawful and unconstitutional conduct in the first place. And if they don't do that, then the next time they're in power, it'll be worse, as you pointed out. And any Department of Justice lawyer that doesn't toe the Marxist, globalist, uniparty, deep state line, however you want to call it, will be targeted for the millions of dollars in fees and challenges and destruction of their reputation and good name, simply because they disagreed with what the elite group in charge wants to do. And that's not democracy. That's not consent of the governed. It's the antithesis of that. It is Orwellian authoritarianism of the likes until now we've never seen in this country.
You're exactly right. John Eastman, thank you so much for joining me today. And folks, again, go to givesendgo.com/Eastman to donate to John Eastman. Thank you, sir.
Thank you, Jenny. And thanks for your audience to put me over the top. I got a strange feeling that's going to happen today. Thank you. Take care.
Thank you. Today, we talked about the Supreme Court and what it means to have justices who take the Constitution seriously. We talked about James Comey and what it means to have powerful people who are finally, hopefully, potentially held accountable. And we talked with John Eastman about what it looks like when the legal system is used as a weapon against those who dare to represent an unpopular client. These are not abstract constitutional questions. They are questions about whether the rule of law means what it says, whether it applies equally to everyone. Tea Party Patriots Action believes it must, and we are going to keep fighting until it does. One more time, before we go, call your senators. The number should be on your screen right now, 202-224-3121. Again, 404-224-3121, and tell them to pass the Save America Act and fully fund the Department of Homeland Security and the Secret Service. And you can go to passthesaveamericaact.com for more information about the Save America Act, or go to teapartypatriots.org to learn about everything we're doing and how you can be more involved. And before we go, I promise you those King Charles jokes, and I'm a woman of my word. King Charles addressed a joint session of Congress yesterday, only the second British monarch to ever do so and the first king. And he spoke at the state dinner at the White House last night. He came prepared, and he said, and I'm paraphrasing here, that if it were not for Britain, we would all be speaking French, to which I say, thank heavens for Britain. And on the subject of our history together, he said at the state dinner at the White House was, quote, a very considerable improvement on the Boston Tea Party. As a modern-day Tea Partier, I appreciated the reference to the protests that sparked the modern-day Tea Party movement. Let's play that clip now.
Thank you, Mr. President and Mrs. Trump, for your splendid dinner this evening, which, may I say, is a very considerable improvement on the Boston Tea Party. So, whether your cup contains tea, wine, Scotch whiskey, bourbon, or even cola, let us raise our glasses and voices as we toast the past, the present, and the future, thank you, of our two proud and allied nations. To the United States and the United Kingdom, God bless both our countries.
Thank you very much. Thank you. There's your great job. That's so beautiful. That's good.
I love that. And here's what I love most about it. It's a king who understands the Anglo-American constitutional heritage better than many people who went to law school. The common law, the Magna Carta, the Glorious Revolution, and the principles of limited government and individual rights. Those are British exports that became the foundation for the American Republic. And the two countries that share that heritage have a bond that goes deeper than politics or diplomacy. I'm Jenny Beth Martin. Thank you for watching The Jenny Beth Show, and we'll see you next time. If you enjoyed today's conversation, go ahead and hit like and subscribe. It really helps us reach more people who care about liberty and the Constitution. You can find this and other episodes at jennybethshow.com, as well as Facebook, YouTube, Rumble, Instagram, X, and your favorite podcast platform.
The Jenny Beth Show is hosted by Jenny Beth Martin. The Jenny Beth Show is a production of Tea Party Patriots Action. For more information, visit teapartypatriots.org.